Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflict or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as your Law Intellect. If you are new here, welcome. If you have been here and rocking with me for a while, welcome back. Thank you to all of my members and all of the new members that have just recently, in a few minutes ago, received a membership as well. I hope you guys are having a fantastic day. I really do. And thank you guys again for coming and supporting my dad. You know, he's overwhelmed and he's very excited and very grateful that, he's not over there talking to himself, coming on, doing what he loves to do. And you guys are supporting him like you guys have supported me. And for that, I appreciate it. It's a lot of mess going on in the church, but you still got some people that just want to bring forth the pure word of God. And that's what's going on over there on his channel. You guys, we have a lot to discuss, and we're going to take our time in this discussion because Duane Youngblood, let me give a brief summary. So I gotta sit back. TD Jakes has sued Duane Youngblood for a conversation he had on the Larry Reed Live platform. Well, he made allegations against TD Jakes, and so TD Jakes sued for defamation and a civil conspiracy. So what TD Jakes did was, before the answer or response was even filed after he sued Youngblood, his attorneys asked for expedited discovery. So if you guys have followed me for a while, you know that in every course of litigation, we have something that's called discovery. And in discovery, we do things like we subpoena individuals for documents. We subpoena individuals to testify in depositions, which is under oath, with a court reporter that is transcribing it. We have what's called written discovery, where we send out what's called interrogatories, where we ask a slew of questions. I believe in federal court, what is it? Can't go past 25 questions. And you have subparts and you ask the questions. And then you have requests for production of documents. And you have requests for production of documents of which the other side turns over. And all of this is called discovery because we're trying to discover, right? When you file a lawsuit, you may know some of the information, but maybe you don't know all of the information, or maybe you want to add more claims, or maybe you want to amend your complaint and you want to take away some claims. Whatever the reason is, we have discovery. And discovery, depending on the nature of the case, myself, if I was on the case and opposing counsel, we would meet and confer, and we would come up with a plan. We'll come up with a plan. We doing discovery for this many months. We plan on doing written discovery. Initial disclosures is something they have to do it as soon as the case, like at the beginning of the case, regardless of discovery, you're supposed to turn over your initial disclosures. But what Jakes did was, he said, well, we want to amend our complaint because they have a bunch of John Does. So they have this theory that there was some co-conspirators and that it sounds like it was a shakedown trying to get money from Jakes. So what they requested the court do was allow them to get discovery right now because they're alleging that whoever's a part of this conspiracy, they might destroy the documents. So we might need to preserve these documents. We don't want them to have a chance to destroy, shred, do whatever with these documents. So judge, we need it right now, right now. And then so then after that, Youngblood, he was pro se. He was representing himself. He asked the court, hey, Your Honor, I plan on filing a motion, an anti-slap motion against this lawsuit. And so I'm going to need a little bit more time. I have been in contact with local counsel, and I just have to get my coins together because I only work part-time, but I have been in talk with local counsel. Well, Jakes responded and said, Judge, we don't think that he should be able to get an extension of time to respond. He has a lawyer, and the lawyer's name is Blackburn, because Blackburn is the one that was pre-negotiating before we filed the complaint, trying to basically get money out of us in order for him, I guess, to stop talking. Well, in the letter, in the response, in opposition to the extension, they basically was making it seem like, it's probably a lawyer that helped him with this writing. It's probably a lawyer, all of that. Well, as soon as they filed that, it seems like some lawyers entered an appearance, and I think it happened like live while we were talking about it. Some lawyers for Youngblood entered an appearance. So he immediately entered the appearance, and the judge did an order allowing for the extension of time for Youngblood to respond so he can file his motion for an anti-slap. And then also, he said by today, January 6th, the judge said, you need to respond to Jake's request to expedite the discovery. And so at around 5-ish, that was done, where there was a response to the discovery. And I only read just a little bit because you guys know I want you guys to get my real, reaction. Because at first, because I've been wearing this little, hood ponytail for a little bit. You know what I'm saying? I need to go get my hair done. So I was going to do the video, just do my little avatar. And then I said, no, we're family here. So I'm just going to go ahead and rock the jacked up ponytail so that you guys can see it as I read, how we do. So because I'm willing to embarrass myself, on this video, I'm going to need you guys to make sure you hit that like button. Okay. Subscribe to the channel if you have not done so already. Because what we're going to do is we're going to get into this document. Okay. Hold on 1 second. Okay. Hold on. Okay. You know what? Attitude and Tylenol. Oh, only you guys can make me feel better when I feel like I look like trash. Thank you so much. Thank you. You guys are so sweet and so kind. Okay. You guys are so kind. So kind. All right. But I'm going to get my life together. It's been rough. It's snowing outside, but I'm going to get my life together. Don't worry about it. But I digress. Before we get into this, though, there's been a couple of, I guess, fake pages that have been commenting about this topic, and they've been very rude and disrespectful to me while they were commenting. I would really appreciate it. I will put the link on here. If you would not hide behind me getting off the video and then commenting disrespectfully and just like say it to my face. That's all I ask. Because other than that, you're not going to get a reaction from me. I'm just going to delete you and block you. So if you want to get a reaction from me, like a real live, pure reaction, just say, hit the link. Pam, why don't you put the link down so I can hit the link? Do that, okay? I want you to be like, meet me at 3:00. That's what I want you to do. Don't come under my comments because you're not going to get any response from me if you can't show who you are. That's all I ask. Okay. Thank you, Kelly. You guys are so wonderful. You said, oh. Thank you. Sharon said they're not here for my hair. You're here for the content. Okay. All right. Thank you, the woman he chose. I appreciate that. All right. So let's pull up this document. You guys are piling in here. You didn't miss what much. I was just doing, let me see. Hold on. Because they did make me like start all this stuff all over again. Let me see if I can add this to a slide. Upload the file. Response. I might have to do it this way. Let's see. All right. We'll wait for this to okay, I'm like, you really taking a long time here. You know what I'm saying? And me up here working like this. So this is the response in opposition, okay? This is the response. And let me see. Let's go through this. I know it's kind of small because I had to put it on the screen from a different way than what I usually do, but let's get through this. This is Youngblood. As you see, this is Thomas Dexter Jakes, or Bishop T.D. Jakes as we know him, versus Duane Youngblood, John Doe 1 through 10, okay? And this is the response in opposition to plaintiff's motion for expedited discovery. So let's get into this introduction, okay? After I read the introduction, I'm going to go back to the comments. Defendant Duane Youngblood respectfully opposes plaintiff Bishop Jakes' motion for expedited discovery, which represents an unwarranted and premature attempt to bypass the orderly procedure of the Federal Rules of Civil Procedure. Plaintiff alleges defamation and civil conspiracy based on speculative and unsubstantiated claims involving alleged statements made decades ago. Plaintiff further seeks to justify his expedited discovery on the dubious premise of uncovering a purported conspiracy involving unidentified individuals, John Does, without providing any factual basis for these assertions. This motion for expedited discovery is not only procedurally flawed, but also imposes undue burdens on third parties while failing to meet the required threshold of good cause. Courts have consistently denied such fishing expeditions that are disguised as discovery requests, particularly when grounded in conjecture rather than evidence. So basically, when we engage in discovery, is typically, it doesn't have to necessarily be admissible or relevant when we first go through, or however, it needs to lead to evidence or has the tendency to lead to admissible evidence. So they're basically saying you're going on a fishing expedition, just hoping, crossing your fingers like, Lord, 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 please, I'm going to find something. That's pretty much what they are saying. Here, plaintiff's pleading failed to establish any immediate harm or urgency warranting deviation from the standard discovery practices. Moreover, plaintiff's sweeping and intrusive discovery demands lack proportionality and specificity, further underscoring their impermissible nature under established legal standard. So it's basically overly broad. You know, you need to be a bit more specific. You can't just say, I'm gonna need all your phone records. Like, no, it needs to be, a bit more specific. I don't know if that's what they're saying. I'm just using that as an example. If the court is inclined to grant plaintiff's motion for expedited discovery, defendant respectfully requests reciprocal permission to issue subpoenas for deposition testimony and documents from several men who have reported experiencing similar acts of sexual assault and harassment perpetrated by plaintiff. This information is critical to refute plaintiff's carefully curated public persona of feigned emotional distress and allegations of victimhood. Is that not a Harvard paragraph right there? Like, what? Okay. So what he's saying is, we believe that you shouldn't be allowed discovery, but hey, if the court wants to give discovery, it should be on both sides. And we want to know about these alleged, I guess he's saying there's some alleged other people that is saying that they kind of experienced the same type of stuff. And so fair is fair. You want to expedite it, I want to expedite it. Or we can just wait and see what happens. You said SAT words. Mm-hmm. Okay. Okay. Mm-hmm. Yeah. Seems like he said Youngblood sounds like he's ready to fight. That's what it sounds like. He doesn't plan on sitting on his hands. Sounds like he's ready to fight this thing. Let's go on. As detailed below, defendant asserts that plaintiff has exploited his position of power within the pulpit to target young men, many of whom have shared with defendant their eerily similar and times more graphic accounts of misconduct by plaintiff. These testimonies and related evidence are essential to providing a broader context to defendant's statements and to establishing a pattern of behavior that contradicts plaintiff's claim of defamation and conspiracy. Accordingly, defendant respectfully requests that this court deny plaintiff's motion for expedite discovery in its entirety. If the court is inclined to grant plaintiff's request, defendant requests reciprocal or reciprocity in the form of depositions and document requests from additional victims of plaintiff who are all eager to come forward and testify. This is all allegedly. My God, today. Thank you, Vicky. Thank you for the super chat and welcome to the Intellects. Thank you so much. Hit that like button, Vicky. Wow. So what is he alleging is that what he's basically alleging that some people have confided in him and he can get those testimonies early too. And he said this is what's going to help his case to show to prove that this defamation lawsuit is basically bogus. That's what he's alleging. All right, let's go on here. I do what's needed. Name changed. Yeah, I can be respectfully disrespectful. But some people, what happens is you have to let them know it's cool to have different opinions. We disagree, we fight. You might see me at other platforms. I don't fold. I don't go with what my people I'm cool with or I like. If you wrong, I'm gonna tell you wrong. Like that's just who I am in real life. And I feel like if you're friends with anybody, and I look at all of you guys as family, as weird as it sounds, but then I'm gonna tell you about yourself. If you take out the time to try to tell me about myself, then I'm going to do you the same courtesy. Do unto others as you have them do unto you. That's my mantra. And so, yeah, I can let you know and still maintain my dignity and be respectful. You might not even know you got read a little bit till a couple of days later, But yeah, I don't let people just say anything over here, and my mods don't either. So that's that. Or to say things that people can come back later and look at the comments and then it starts becoming a thread. Like, no, I cut the infection off from the root. So let's go on. Allegations from plaintiff's complaints. Plaintiff Bishop Jakes initiated this litigation on November 25th, 2024, alleging defamation per se, civil conspiracy against defendant Duane Youngblood and unidentified individuals, John Doe's 1 through 10. The claim stemmed from defendant's public recounting of a childhood incident in which defendant alleged he was sexually assaulted by plaintiff. Plaintiff's complaint also implicates a podcaster, claiming they amplified these allegations on widely viewed online platforms, thereby causing reputational harm to the plaintiff. Okay, it was a footnote up here. Where was this footnote? I got thrown off. So up here, let's go back a little bit. It has a sentence that said these testimonies and related evidence are essential to providing a broader context to defendant's statement and to establishing a pattern of behavior that contradicts plaintiff's claim of defamation and conspiracy. So they have a footnote that says, at the onset, it is important to note that plaintiff has identified attorney Tyrone Blackburn as a defendant in their moving papers. Poor editing aside, not you going in on their editing, poor editing aside, attorney Blackburn is not a defendant in this case. So apparently they may have mistyped and said something about Blackburn being a defendant or something. I don't know what they're referring to because they didn't put a citation. So, yeah. According to the complaint, defendant's statement and subsequent discussions on social media platforms and podcasts were part of a broader conspiracy to damage plaintiff's reputation. However, wait a minute, hold on. However, the complaint fails to provide factual support or specific evidence tying defendant to any coordinated defamatory actions involving the podcaster or other unnamed individuals. Instead, plaintiff relies on conclusory assertions of a conspiracy without detailing the mechanisms or participants involved. So he's basically saying you're coming to a conclusion without going through a whole factual analysis. You just came to the conclusion it was a conspiracy, but you really don't have the facts to even back up a conspiracy. So it's all just conclusory. The complaint further alleges that unidentified co-conspirators disseminated false claims to extort money from plaintiff. Yet it provides no substantiating details, such as communications, agreements, or identifiable individuals. Plaintiff's reliance on vague and speculative allegations underscores the lack of a concrete basis for the discovery sought. The described events, including podcasts aired on October and November 2024, are presented without demonstrating any immediate or irreparable harm that would justify expedited discovery. As the complaint itself highlights speculative and unsupported claims, it fails to meet the standard required to warrant departure from standard discovery protocol. Plaintiff's generalized assertions do not establish a compelling need for expedited discovery, nor do they provide sufficient details to substantiate the requested relief. Okay, let's get into the defendant's position. You guys, make sure you guys hit the like button for me, please. Thank you so much. Thank you, a lady 747. It's all good. Henry said, Pam, do not have to step out of character. There are some here that loves her enough to find something. You find something else. Thank you, Henry. I appreciate that. Yeah, they be testing me sometimes. My sister said, if you're not a hater, please hit the like button. If you're not a bushwatcher, just trying to see what I say so you can say it later, hit the like. Well, if you're going to use some of my commentary, even if you don't, actually clip my videos, which some of you guys do, and I don't even strike your channels. You know what I'm saying? You think YouTube doesn't let me know it's a copyright match? And they ask me, yo, Pam, what do you want me to do? I'm like, let them live. We all got to eat, YouTube. We all got to eat. Yo, my logo and everything, my name, all of that it's actually my intellectual property. But when they use it all over my videos and stuff, I'd be like, okay. So I let people live. So I'm not that type of girl. You know what I'm saying? I think we all can eat. We can all be in the same space. But it would be nice if some of you guys actually just hit the like button. That's it. Just hit the like button. At least if you're gonna like my comment and basically regurgitate it, hit the like button. That's all I'm asking. Thank you so much. Oh no, they don't ask first. And everybody sends me clips all the time. And then it's the people that hate my guts too. I'm like, you know, it's the very YouTube is just interesting. It's an interesting place. It's not real. YouTube is not real. So let's get into the defendant's position. Defendant Duane Youngblood offers a detailed and deeply personal account of his interaction with plaintiff Bishop T.D. Jakes, alleging a series of events that highlight inappropriate conduct and emotional manipulation. These incidents, according to defendant, are critical to understanding his subsequent public statements about plaintiff. Mr. Youngblood recounts an incident occurring during his late teenage years after a church service where he had been driving plaintiff to the residence where plaintiff was staying. Upon arrival, plaintiff invited defendant inside for what initially appeared to be a pastoral conversation. So he's going into what he said on this podcast. Okay. This discussion turned personal and emotional, providing defendant with an opportunity to express deeply rooted struggles, including challenges in his father-son relationship. So they were having a heart-to-heart. This felt like the pastoral counseling, that he may need it. He was pouring out his guts, and that's what it sounds like this conversation was at the big dining room table. However, the interaction culminated in an unwanted and inappropriate advances by plaintiff who attempted to kiss defendants. The following morning, plaintiff contacted Mr. Youngblood via phone, during which plaintiff proposed conditions for an ongoing relationship. Plaintiff purportedly outlined explicit terms including exclusivity, secrecy, and a promise of financial support. Defendant asserts that he unequivocally rejected this proposition and sought to distance himself from plaintiff, though his continued presence in the church environment made complete avoidance challenging. These events have had a profound emotional toll on Mr. Youngblood, from his impressionable teenage years through adulthood. Defendant has consistently maintained a feeling of betrayal and disillusionment. The spiritual and pastoral role plaintiff held in defendant's life amplified the gravity of plaintiff's misconduct, leaving defendant with lingering trauma and questions about his self-worth and faith. Years later, under the direction of a senior church leader, efforts were made to mend the strained relationship between plaintiff and Mr. Youngblood. Defendant alleges that during a private conversation at this time, plaintiff admitted to inappropriate behavior, attributing it to his own struggles and rising prominence within the religious community. Despite this interaction, defendant states that trust could not be restored. So he's alleging that he went to his senior church leaders and there was some form of admission, is what he's alleging. Goodness. Okay. The relationship between defendant and plaintiff has remained tense and marked by distrust. While both parties maintain a professional association due to their roles within their shared religious organization, defendant asserts that unresolved tensions have persisted due to plaintiff's sexual assault of defendant. Defendant Youngblood has been rehashing this traumatic encounter since the 1980s. He has not deviated from his assertions, published a book concerning this incident, wrote letters to loved ones discussing this incident, and sought medical treatment concerning this incident and its related trauma. To say that defendant Youngblood is conspiring to harm plaintiff Jakes is foolhardily at best, the delusional at worst. This is defendant Youngblood's lived experience, which the First Amendment to the United States Constitution affords him the right to openly express. Defendant contends that his public statements about plaintiff are rooted in personal experience and a need to confront past harms. He refutes the notion that these statements were made with malicious intent or as part of a broader conspiracy. Instead, defendants positions his actions as an attempt to address and reconcile deeply personal experiences of childhood abuse and betrayal under circumstances that were supposed to provide spiritual and emotional support. Well, he wasn't like a kid, though. He said childhood abuse. Okay. So what do you guys think? This is what he's saying. He didn't have any ulterior motives, no ill will, no malice. He is alleging this is his experience. And so that's all he was trying to do was to talk about his experience, and he should have the right to under the Constitution. That's what is pretty much what his argument is. So, what do you guys think? What do you guys think? Thank you so much, Sheila, for the Cash App. I appreciate that. Not Walmart telling me my package is delayed. Oh my goodness. Kelly said, in my opinion, he's not telling the truth, but I respect the argument. Andrea says, so he's saying he has contemporaneous notes to and by multiple people. That's pretty much what it sounds like. He's saying he did go to his senior leader. See, my thing is, when I read his letter to the court, he being Youngblood, it sounded like the person he went to, unless it was somebody different, I thought the person he went to was one of the other people, because he didn't just mention Jakes. Jakes was kind of like a small portion of this conversation. He mentioned some other people. And so one of the guys I think was supposed to be like done the same, the one he went to, he's alleging was inappropriate, I thought. Maybe not. But I mean, I can't see that person coming forward to help if you said the same thing about them. Okay. C Breeze 40 said, I believe some victims do have childlike tendencies. That's why they're picked. Interesting. Okay. We got any psychologists here? Any psychology? Demetrius said, no proof, Duane, no win, unfortunately. This is what I want you to do, Demetrius. I want you to show me, aside from Monica Lewinsky, who actually typically has physical evidence when it comes to these type of cases. I'll just, wait for your response, I got time. Who has that? Because what I don't want to do with this situation, and this is not related to specifically this case, but we have a lot of these cases when it comes to Diddy, Jay-Z. We have other cases we talk about. And part of what Jay-Z's issue is because, yes, he can come with all the pictures in the world, but the court cannot determine credibility. Why is your word better than my word? If I say you did something and you just say you didn't, what makes your word more special than my word? If it's all about credibility because it's your word against mine. The courts do not deal with credibility. That is for a jury of your peers if you do a jury trial. They assess credibility. And so what you don't want to do is put out, when you have people that are alleging they were victimized, that they're like, no, because nobody's going to believe me. That's pretty much what people say while they waited 50 years for those type of comments. That's just not how that works in court. So, you said text message. Any text messages, Youngblood said he confronted him. Why didn't he secretly record this alleged conference? Well, Kelly, I don't know if it was text messages in the 80s. Wasn't it supposed to be like the 8 ladies, early 90s? I don't know if he would have text messages. Not sure. We got to take ourselves back to that time. Now, he mentioned letters. he mentioned going to, going to the pastor and all of that. See, we record folk on phones now. We do all of that. But we wasn't doing all that back then. That's it. Thank you, Demetrius. I just want to open up your mind on the thought process here because, and it's not specific to this case, because he's saying actual assault, but it sounds like he's alleging he attempted to do something to him. So I don't know, how, maybe it's different prongs. I don't know. But he's using the term actual assault in here. So maybe that's his perception of what was going on. But to me, if it's attempted and it was a failed attempt, then I don't know. Wouldn't that be like attempted or something? He said the religious sector is different because you come looking for direction and validation. That is true. Most, people have considered the church being a hospital. You know what I'm saying? And because of that, you have a lot of people that have issues and vulnerability that occurs in the church. And you do rely on leaders and you confide in people. It is. It's a place of vulnerability. It absolutely is. I'm sure, like as an adult, my pastor knew a whole lot of stuff that probably my therapist ain't know, so I agree with that. Overthought said it sounded like he tried to kiss him and it didn't work. Yeah. Ray said he confronted TD at a hotel later in life, I believe late 90s, while Mrs. Jakes was asleep. Okay. Yep, I remember the hotel confrontation, but he's talking about a leader. Apparent, because he said that Youngblood said that in another, when he tried to get the extension and he put all that extra information in there. So that's why Jakes was trying to strike the pleading, because he was like, all this ain't necessary for you asking for an extension. And I guess Youngblood was like, all the stuff you put in your complaint wasn't necessary either. I don't know. The court didn't address that. But in the order, obviously what they didn't strike it is still there. But nonetheless, he did say he sat before a leader and they talked about it. So maybe that's a different occasion, Ray. I'm not sure. Scorpio said, I believe him. He talked about other people who did stuff to him. He talked about what he did to other kids. I'm gonna have to reread that because I'm not sure what you're trying to. Ray said they both petty. It's a lot, So let's go on. Make sure are you guys hitting that like button? So now he goes into the legal standard when you're trying to request an expedited discovery request. Is an exception to the ordinary course of litigation. I mean, it's an exception to the rule. Generally speaking, you're going to get discovery. The timing of it usually does not happen before the other side even gets a chance to respond, which is what they're asking. And again, for those of you that don't know, what he wants information related to, he wants information from the Larry Reed Live platform, and I think Larry Reed, and I think they get into the specifics because I don't remember what the specifics were that they're requesting. So they have expedited discovery as an exception to the ordinary course of litigation, permitted only when the moving party demonstrates good cause. And that's over there at Gucci Am Inc. v. Daffy's, according to them. And this is an unpublished opinion, so it's just persuasive authority. But here's Westlaw. WL is a legal software site where we do our research on. Courts balance the need for such discovery against the potential prejudice to the responding party. Ensuring adherence to the principles of fairness and proportionality. Factors commonly considered include, so these are the factors the court will consider to see if expediting discovery is necessary. If there's this existence of a pending preliminary injunction, I can't even talk. Existence of a pending preliminary injunction. The second, I guess, factor that should be considered is specificity and breadth of the discovery request. Courts favor narrowly tailored requests over expansive demands, ensuring they directly address issues requiring resolution. the burden on the responding party or third parties, the potential harm or inconvenience caused by compliance with the discovery request. So is there going to be harm or a burden or inconvenience for the person that they're asking for this information from? If it would be potentially inconvenient or harmful for Larry Reed or Larry Reed Live, because that's who they're talking about in this subpoena they're trying to get out. Temporal proximity to standard discovery timelines. Requests made significantly in advance of typical discovery timeline requires additional justification. The likelihood of irreparable harm without discovery. The moving party must demonstrate that expedited discovery is critical to preventing imminent and irreparable harm. The Third Circuit and district courts within Pennsylvania adhere to these principles. Let me move this over here so y'all can read along. Oh, it is on there. The Third Circuit and district courts within Pennsylvania adhere to these principles, often invoke the good cause or reasonableness standard, and that's in Leon v. Towanda Borough, and that's in the U.S. District Court for the Middle District of Pennsylvania. They emphasize the importance of balancing the urgency of discovery against potential prejudice to the opposing party, particularly when the allegations are speculative. Similarly, in Final Visa Inc. v. Does 1 through 9, the court underscored that good cause requires specificity in the request and a direct connection to the issues at hand, rejecting requests grounded in broad and unsupported allegations. So they have authority of which the court says, you have to have good cause in order to get this early discovery that you're asking for. And they also have the case that basically says that you have to specify in the request a direct connection to the issues at hand. Okay. Additionally, courts have highlighted the risk of abuse when expedited discovery is used as a tool for fishing expeditions rather than addressing genuine procedural needs. For instance, in Better Package Inc. v. Zing, the court warned against granting overbroad discovery requests under the guise of expedited discovery, emphasizing the need for reasonable boundaries. And that is in Better Package Inc. v. Zing, and that's over there. That's another unpublished opinion over there in the District of New Jersey. I'm going to need y'all to start using some published opinions, okay? Published opinions are what's binding, all right? These principles ensure that requests are narrowly focused and proportional to the matter at hand. Thus, expedited discovery is not a matter of right, but an exception that must be justified by clear and compelling circumstances. Plaintiff in this case bears the burden of demonstrating not only the necessity, but also the fairness of departing from standard discovery protocol. And then he's going to get into his argument. Now you guys see what the law says about what the court has to decide and put that with the facts as the court has it on whether expedited discovery is even necessary. If you guys just got here, you guys know that basically they're saying that it should be denied because there's no reason for expedited discovery. He does plan on filing a motion to dismiss the case in an anti-slap, but he's saying, hey, if you gonna do that, then I want it to be reciprocal. We both gonna both be able to subpoena people. You just not gonna be able to subpoena stuff. I want to subpoena stuff too. So that's where we are for all you guys coming in. Make sure you hit the like button. Hey, I see the blues in here. Hey, Nyla. Good to see you, sis. I'm just over here talking about the church folk. The argument here is plaintiff has not established good cause. Plaintiff's claims are grounded in speculation rather than concrete evidence. The assertion of a conspiracy involving unidentified individuals, John Doe's, is unsupported by specific facts or documentation. Courts have consistently held that vague and conclusory allegations cannot serve as a basis for expedited discovery. In Final Visa, the court rejected discovery requests that relied on broad assertions without substantive evidence, emphasizing the good cause requires specificity and factual grounding. They say he hasn't established good cause. The second thing is there a lack of immediate or irreparable harm. Plaintiff has not demonstrated that expedited discovery is necessary to prevent imminent harm or irreparable harm. The alleged reputational damage and potential document destruction are speculative and unsupported by any evidentiary basis. So they have another case in IQVIA v. Breskin. The court denied expedited discovery where the moving party failed to establish a tangible and immediate risk to the case's integrity. Okay, that's another unpublished district court. That's in the Eastern District of Pennsylvania. No connection between request and alleged conspiracy. Okay. The requested discovery seeks expansive and intrusive information from third parties, yet plaintiff fails to show how these requests are directly tied to resolving the alleged conspiracy. Courts have emphasized the importance of narrowly tailoring discovery to address specific and relevant issues, as seen in Better Package Inc. v. Zhang Supra, where overbroad discovery requests were deemed improper. Okay. What y'all saying? Let me see. He arguing with the she said, does he have a real legal argument? Listen, he's only arguing against expedited discovery. He is correct. It is the exception. It is not the rule. So you have to show that you have good cause, meaning you got irreparable harm. Like if we don't get the discovery now, it's going to go away. You have to have some reasoning behind what you're saying. You know what I'm saying? So, I mean, the law is what the law is. I just don't understand why they're using all these unpublished opinions. But I mean, who am I? So they said discovery requests are overly broad and burdensome, intrusion into third-party privacy. The subpoenas target individuals and entities not directly named as defendants, imposing undue burdens on third parties. These requests seek private communications, financial records, oh, wow, and other sensitive material without sufficient justification, violating the principles of proportionality and relevance under Rule 26b1. I didn't know they was asking for all that. My goodness. The requested materials are far-reaching and lack any direct connection to the plaintiff's allegations of defamation or conspiracy. In Leon v. Tawanda Borough, the court stressed the necessity for narrowly defined and focused discovery requests to prevent undue harm to non-parties. Such invasive demands risk overburdening third parties who are tangential to the core claims in the case and the defendant. Moreover, the potential exposure of personal and financial information creates unnecessary risk of harm to the third party's privacy and reputation. Courts have long recognized the importance of balancing discovery needs against these risks, particularly when the discovery sought does not demonstrate direct relevance or necessity to the claims at issue. The next reason they have excessive scope relative to allegations. Plaintiff's discovery requests span a broad time frame and include materials unrelated to the core claim of defamation and conspiracy. By seeking expansive categories of documents, including speculative, financial motivations, and peripheral communications, the plaintiff's approach imposed undue burdens that exceed the permissible scope of discovery. The lack of specificity in the request further compounds their overreach. For example, requests targeting all communications between the defendant and any third party over several months are neither proportional nor tailored to uncovering relevant evidence. Oh, wow. Courts routinely reject such expansive demands. In Better Packages Inc. v. Zhang, the court required precise and narrowly tailored discovery, cautioning against overbroad requests that effectively operate a fishing expedition. Then it has all the case law there. The requests here appear to mirror this impermissible approach, lacking the requisite focus to justify the burden imposed on both the defendant and third parties by seeking discovery far beyond the allegations and issues central to this case. Plaintiff underscores the speculative nature of their claims and the inappropriateness of expedited discovery in this instance. Plaintiff's discovery requests span a broad time frame and include materials unrelated to the core claims of the defamation and conspiracy. The lack of specificity in the request further compounds their overreach. Courts routinely reject Such expansive demands is seen in Better Package Inc., where the court required precise and early tailored discovery. Good gosh. His attorney had a lot to say. My goodness. Like, I need him to breathe. There's a lot going on in this doggone document. Okay. Yeah. We need an interlude or something. I don't know.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
We needed a break from all of this. Gosh. I'm boring my doggone stuff and I do this every day. Jeez, oh Pete. All right. That is the Right Reverend Bishop Bling Bling Lamar Whitehead. Whew. Let me see if this works. Procedural prejudice to the defendant. Okay, I don't see that. So this is defendant specific request because I don't even remember them asking for all of this. So plaintiffs request 1 through 3 and their deficiency. So what they are requesting, for those that want to know like me, because apparently I forgot, they seek to establish actual identification of the putative defendants, claiming such information is critical for properly identifying the alleged conspirators. However, these demands are legally implausible, burdensome, and inconsistent with legal precedent in the Third Circuit and the federal district courts in Pennsylvania. So they're saying it's legally implausible because it's a lack of specificity and factual basis. Plaintiff's motion fails to establish a factual nexus between the sought information and the alleged conspiracy. Courts in the Third Circuit require a movement to demonstrate with specificity how the requested discovery is essential to their claim. And that's over there in Leon v. Tawanda Borough again, okay? There's no good cause. Then they say it's burdensome and overreaching nature of requests. It's an infringement on privacy rights. Requests 1 through 3 seek broad and invasive personal information about the putative defendants, including their identities and potentially sensitive communications. So that's one of the reasons why. Disproportionate scope and burden. These requests impose significant burden on third parties in the court system, requiring the production of extensive information unrelated to the claims at issue. And then they say inconsistency with legal precedent. I don't understand why they had to separate this like this, because this is basically saying the same thing. They're just doing it by claim, I guess, request. So requests 1 through 3, they're saying those are all the reasons. Okay. Then they got requests 4 to 5. This is what they're asking. Their deficiencies. Plaintiff requests 4 to 5 seek to explore the relationship and interactions between the putative defendant and defendant Blackburn over a 3-month period surrounding the publication of the podcast. These requests are legally implausible, overly burdensome, and inconsistent with established legal precedent in the Third Circuit. So they're basically saying the same thing. They lack a legal nexus. So they're asking for Blackburn an attorney and whoever he may have talked to. What if they trying to hire him or something? You want communications with the attorney. Oh, that's interesting. Okay, yeah, they got that in there. Infringement on attorney-client privilege. I'm like, request 4 to 5 risk encroaching upon privileged communication between defendant Blackburn and his clients. What? Courts have routinely denied discovery requests that potentially implicate attorney-client privilege without a compelling judge. So are they trying to allege that Blackburn might be a part of the John Doe? Is that what they saying? Thank you so so much, J80, for becoming a YouTube member. Is that what y'all hearing? Are they saying, because they keep calling him defendant Blackburn, but I guess they're calling him that because that's what he was called in the original motion filed by Jakes. So are they trying to find a conspiracy, trying to group the attorney in there too? Oh my goodness. Okay. So then they also say excessive temporal and contextual scope. The 3-month period specified in request 45 is excessively broad and unduly burdensome, particularly given the limited time frame relevant to the specific allegation in the complaint. So the allegation in the complaint only talks about the day of the podcast. So they're trying to do 3 months because they're trying to somehow tie together when this attorney and when this attorney sent this demand letter, because remember, that's what triggered all of this. This was the domino effect, was when the attorney Blackburn out of New York was representing Duane Youngblood, I guess for negotiation purposes. He sent a demand letter. The demand letter was allegedly, I have not seen it, but according to them, it was $6 million. TD Jake said, this sound like a shakedown. I ain't giving you $1. I ain't did nothing, so I ain't giving you nothing. And so he filed this lawsuit in response. So apparently it sounds like he's trying to say that everybody was involved in trying to get this money. How can they even look into that without it being an attorney-client situation in the discussions? Like, how do you... No. 504 said lock everybody up. Kelly said, definitely making some good arguments. I mean, some of this stuff is like, okay. Inconsistency with legal precedent, procedural guidance against a fishing expedition. Courts have consistently rejected discovery requests that resemble fishing expeditions, particularly in the context of expedited discovery. And they got case law. The court denied a motion for expedited discovery where the requests were overly broad and unsupported by a clear connection to the claims. Requests 4 to 5 similarly seek extensive information without demonstrating direct connection to the allegations of defamation and conspiracy. They spent a lot of time on this motion. This is very, very long. Violation of the proportionality principle. The federal rules of civil procedure require that discovery requests be proportional to the needs of the case. Okay. Plaintiff's request 6 to 8. It was all them requests. Where was I at? Oh my goodness. Plaintiffs' requests 6 through 8 seek information related to statements made by the podcaster, including their knowledge of the alleged November 15th extortion letter and interactions with defendant Blackburn. These requests are legally implausible, unduly burdensome, and inconsistent with established legal precedent. And third, okay, we read that. And so they're saying it's speculative assertions, lack of demonstrated need, burdensome and overreaching nature of the request, infringement on third-party privacy, disproportionate to scope and burden. They got a lot of reasons why they shouldn't be able to get this discovery. Inconsistency with legal precedent. And then plaintiff request 9, okay? Plaintiff request 9 sought data and material to augment plaintiff's current understanding about the putative defendant's financial motivation to act in furtherance of and in accord with defendant Youngblood's false allegations against Bishop Jakes. This request is legally implausible, unduly burdensome, and consistent with legal precedent in the Third Circuit and the Federal District of Pennsylvania. So they're saying it's a speculative foundation, irrelevance to the court claims, burdensome and overreaching nature of requests, infringement on privacy and confidentiality, excessive burden on responding parties, inconsistency with legal precedent, failure to meet the good cause standard. And then they're saying it's premature. The foregoing arguments make clear that plaintiff requests for expedited discovery are not only legally and procedurally inappropriate, but premature. Here, plaintiff has offered no legitimate reason to circumvent the established 26F conference or any other round of initial litigation. Further, given the frivolous nature of plaintiff's lawsuit, Mr. Youngblood fully anticipates filing a 12B6 motion to dismiss, a likely motion for sanctions, and if necessary, an answer and new matter to the complaint, along with any other appropriate requested relief. Why y'all gotta put this in bold and underline it? See, now you got me looking at the formatting here. Like, I'm gonna need y'all, if you're gonna do a tab right there at the beginning, then you need to do your underline after the fact so you don't have all these lines over here at the beginning. That's the first thing. Secondly, if this is a sub D, right? C, D, we need consistency. That didn't need to be bolded and that didn't need to be underlined, okay? All that wasn't even necessary. For these reasons and those discussed infra, Mr. Youngblood respectfully asked this court deny plaintiff's request for expedited discovery as frivolous and premature. And so we are reaching the conclusion that took a long time because they had a lot to say. But you know, we can't go up in there and talk about people's, what was it over here where they said in the footnote when they talked about his typos and stuff, that underlining and boldness just was not necessary. Okay, all right, y'all remember that next time, all right? Because I know y'all probably watching these videos. When you can't put a footnote that say at the onset, it is important to note that plaintiff has identified attorney Tyrone Blackburn as a defendant in their moving papers. Poor editing aside, attorney Blackburn is not a defendant. See, if you gonna get smart with people, okay, I be getting smart too, so I get it. If you're gonna get smart with people, you better make sure every I is dotted, every T, your indentation is correct. You make sure your font size is what they tell you to do over there in that local district. You make sure the spacing is accurate. You got to make sure all of that. Then you go get smart. You know what I'm saying? All right? Because you can't, because then what they going to do, they're going to respond and they're going to say something smart. When they do a reply to your response, they're going to get smart. All right? That's it. That's my suggestion. Okay. Let's go on. We have a conclusion here. Let me see. What's the conclusion? Make sure you hit the like button. That's the conclusion here. Okay. So Tyrone. Wait, whoa. So Tyrone is going to represent him. My God, today. So Tyrone is going to represent him and then use local counsel, I guess. So this was Tyrone's work. Okay. Oh, God. It's all coming together now. It's all coming together. All right. Did y'all see that? Y'all see Tyrone? Now, let me read this conclusion. You don't know who Tyrone is? Look, I'm saying it like he our homeboy over here. Tyrone Blackburn is the one that was representing what's his name? Jones in the Lil Rod. Rodney Jones, I think is his name. They call him Lil Rod, that sued one of the first lawsuits after Cassie that sued Diddy and had one of those real colorful complaints where they had all those pictures and stuff in it. He's on that case. Bombshell. All right, let's get in. Let's do this conclusion. And then, yeah, looks like he's the counsel on this. So how is that going to go? You're going to have your counsel? You're going to be trying to ask for emails and texts from his counsel? This is crazy. This is ludicrous. We need to all just pray about it, okay? If you guys need prayer, go on over there to my daddy's channel. He's saved for real. Just go on over there He old school. He's 75. Going over there and get you some prayer, right? He ain't into this celebrity stuff, and I had to make him get on the internet because I want to sit his high end down somewhere and stop driving up and down them highways and byways to go try to help the people know the Lord. So I said, you can do that right over here on YouTube. I'll send a couple of people over there. They need Jesus too. You know what I'm saying? Let's go. In conclusion, plaintiff's lawsuit is baseless, and that fact will be made abundantly clear to the court in defendant's forthcoming anti-SLAPP motion. Plaintiff is attempting to use this court as a means to stymie defendant's First Amendment right and to intimidate a third party. YouTube television show hosts from reporting on legitimate claims of sexual assault and misconduct perpetrated by plaintiff and the other members of the clergy. Plaintiff's actions mirror the well-documented abuses by other clergy who have faced lawsuits for using their positions of power to exploit vulnerable and impressionable individuals. The parallels are undeniable, with plaintiff seeking to portray himself as a victim while concealing a troubling history of alleged misconduct. This court should not permit plaintiff to misuse the judicial process to silence criticism and suppress truth. In conclusion, plaintiff's motion for expedited discovery lacks the necessary factual foundation and fails to meet the established legal standard of good cause required for such extraordinary relief. The complaint relies on speculative and unsupported allegations, presenting vague claims of conspiracy and harm without any substantiating evidence. Plaintiff requests for broad and intrusive discovery are disproportionate to the claims at hand and would impose undue burdens on defendant and third parties. This is a long conclusion, Mr. Blackburn. This is very long. Defendant, in stark contrast, has provided a detailed and substantiated account of his interactions with plaintiff, highlighting the context and motivations behind his statements. These narratives challenge the credibility of plaintiff's claims and underscore the importance of adhering to standard discovery protocol to ensure procedural fairness. Should the court be inclined to grant plaintiff's motion for expedited discovery, defendant respectfully requests reciprocal permission to issue subpoenas to individuals with corroborating accounts of similar misconduct by the plaintiff. Such discovery is essential for providing a complete and accurate representation of the facts for countering plaintiff's claims of defamation and conspiracy. For these reasons, defendant respectfully requests that this court deny plaintiff's motion for expedited discovery, or in the alternative, grant defendant equal discovery right to ensure a fair and balanced process. So I guess they weren't right again when they said that Blackburn couldn't find anybody to sponsor him in Pennsylvania. That perhaps that may be upon information and belief might be a reason why, because he is on here, Tyrone A. Blackburn over there in New York. And yeah, and then the two attorneys that entered an appearance, they're also on there as well. Wow, it's been a long day. My goodness. Oh, early morning advice. Oh, he love it. He all geeked. He coming on. You see, he could just coming on randomly. He like way up here, the camera down here. You know, just work with him. I appreciate y'all working with my dad. You know, he old. I'm just saying. We thank God he's still here. That's all I'm saying. But yeah, he's enjoying it. He definitely is enjoying coming over, and he appreciates all the love and support that he has gotten. So yeah. So what, I don't really know. I don't know what else. What else you guys want to talk about? I mean, that's that. He's denying, he's opposing it. He doesn't want it to happen. And that's that. Oh, thank you. I let him know, he'll be geeked. He'll be geeked. Oh. Yeah. You said, what's this page now? Child, now I gotta go find it. Where my Alice, can you pull the page up and put it in the chat for me, please, sis? Oh. Thank Thank you so much, Alice. I appreciate that. Okay, so Andrew, Gloria got it, Mo. So you want to go over the actual order? Is that what you're saying? So it's too many people here that just wasn't around for the Whitehead Gloria God saga. But we gonna have to do a live in the membership, girl. I owe you that. You're deserving of that to get a somewhat conclusion. It's not really concluded yet. They're still trying to work it out, but Whitehead is in prison and people are still in court trying to shoot. Pauline Anderson is still trying to get her case won. She still ain't won her case yet. So the young man who sued Whitehead for not paying him when he did his campaign for Brooklyn Borough president, he hasn't got paid yet neither. Apparently Whitehead, they want to allow him to be on Zoom. If he come on Zoom, I'm gonna try to get that link. We gonna all watch him on Zoom. But they wanted him to have a chance to get on Zoom, so they postponed his hearing. Like, he went to court and they were like, with Mr. Whitehead is in prison, but he's still allowed it to be on the Zoom. So they were going to let him come on there. So they postponed it. Then they went on another day, and whatever the postponed date was, like 3, 4. Like, when they postpone stuff in New York, you're not getting a date for 6 months. It is so ridiculous. I have never seen a system so jacked. Like, the way Pauline Anderson stuff is nowhere near towards the end, and they've been in litigation. Like, here in Michigan, they're like, counsel, your case has been on my docket. When we ask for extensions, your case is a 2023. Do you know what year it is? It's 2024 in the end. We need to get to trial. I'm putting you on the trial calendar. Y'all gonna settle, you're gonna try this case. But New York don't give a dang. They take their own sweet time. They'll give you a date in January. Then if the judge, something happens and they can't do it, they'll move your stuff to December of the same year. It's so ridiculous. But anyway, he's supposed to have a video, something coming up. So if he does that, I'm going to get that information, honey. We might have to live stream that. So, yeah. You think California is the same? California, I don't know. I've only dealt with a couple of people that have had defamation lawsuits in California. And they moved pretty decent because I think they did the anti-SLAPP. So that moved pretty decent, the cases I saw. But New York is just different. Like, their state courts, it's crazy how the stuff just lingers. It literally just lingers. It's like, do you guys, hello, anybody home? You guys forgot that I filed something? That would drive me nuts. Because I would just forget about these cases. I'd probably move on or something and forget that I even had a case. But thank you. I appreciate that. Thank you, early morning. I appreciate that. Love Logic said, hello, Queen. Finally caught alive. Have a civil rights lawsuit in Pennsylvania. Can you please help? What is it? Just email me. I might be able to. If it's a 1983, that's my wheelhouse. That's what I do. Now I'll have to, find an attorney there because I don't practice in Pennsylvania, but just judge wants to reduce T.I. and Tiny's Harris lawsuit award of $71.4 million in damages to $17.8 million for their LOL Surprise Dolls lawsuit. That's so you guys know that T.I. and Tiny, they won their lawsuit against LOL finally. I think they lost the first trial and then they appealed and it went back down and got retried. Then they was it like a hung jury or something? Something happened, but I think they tried it 3 times. So what happens is, and this is what I was saying, I think in other people's lawsuit, like even with Tasha K, I was like, why wouldn't your attorney just try to request a remitter? If you can't get rid of the case, try to say that it should be a new trial, then try to at least reduce your judgments. That's another thing that you can do. You can do a remitter, or even if it's too low, you can ask for an adder, on your appeal. And so thank you so much, Crystal, for the super chat. So kind of you. Said, thanks for all you do, Pam. I appreciate that. So it sounds like the judge said, listen, 71.4 is too much, but we will give you 17. Shoot, it's all a lot of money to me. It said, a jury ordered toy maker MGA to pay T.I. and Tiny $71.4 million for LOL surprise dials that infringed the trade of the OMG girls last year. But now a judge wants to lower the amount they receive in damages. A judge wants to axe the $53.6 million of punitive damages. Oh, they want to just take away the punitive damages, which is the punishment, and they just want to give them actual damages, it sounds like, which is $17.8 million. The judge says there isn't enough evidence of bad faith. So there's a tentative order. So it has before the court are plaintiff and counter defendants MGA Entertainment Inc. and the OMG girls. The Harrises filed an opposition to MGA's motion. MGA filed a proposed finding of fact and conclusions of law. Proposed upon consideration of the evidence, the court grants disgorgement of profits of $17,872,000 under common law misappropriation, but does not award punitive damages. Further, the court declines to disgorge profits or enhance the award under the Layman's Act. I mean, 17 million, I could live with that too, but I mean, that's a big difference from 71. I'll be a little touched. I'll be a little touched. Oh, Lord. Henry, y'all not going to make me into a church blogger, okay? We cut up too bad over here. Are you doing the E.J. Newton case from his situation yesterday at the church? I don't even know these people. I know Jace from when I was a kid. I remember him on cassette tapes, okay, with hair. That's how long so I knew exactly who that was. But now you're gonna make me research all of these celebrity pastors. I just can't do it. I don't have the capacity. Sorry, Henry. I ain't got the capacity. But it's a lot of people that's out here that focuses on the church and the church mess. And so they'll talk about it, I'm sure. But I did see the video, if you're asking. I did see the video of which, and I actually did see the orders too. Let's see. I have all the documents and everything. So if you have any questions, I don't mind answering them, but he not getting on my thumbnail. I'm not putting him on there, and y'all not gonna make me into no church blogger. It's not happening. So what had happened was, from what I read, his ex-wife, E.J. Newton, who apparently was like a mentee of, what's that guy's name that been going around lately? That the girl came out and said they was messing with each other? Prophet Lovey. So he was the mentee. So apparently they was feuding on the internet. I didn't even know that. They started beefing. They fell out. Okay. And so when they fell out, EJ is claiming that all these people from Lovey is coming after him. And then I guess Lovey is claiming that when the girls is coming out after him, that's because of EJ. So they blaming each other. It's going like this, right? So then suddenly on Sunday morning, if you guys saw the video, so marshals came up, and not marshals, they were sheriffs. They came up in there and he was like, talking to his 15, 20 people that was there because they pay in the room. So they were up there and he was like, can I help you? Oh, you need to talk to me? Okay, pray saints. And then they wasn't praying loud enough for me, because if somebody come trying to get me up out the pulpit, I'm going to need y'all to pray a little harder, okay? I'm going to need you to get into those tongues, all right? But they didn't do that. They was looking like, what? Okay? They didn't pray hard enough. So anyway, he go out and they was like, okay, you guys play, I'll be right back. So when he leaves out, and then come to find out, his ex-wife alleges, let me tell you exactly what she alleges, okay? So she filed a motion for enforcement to pick up minor children. See, look at me talking about it, and I said I wasn't, but here I go. The court has jurisdiction. Is this the first one? Thank you so much. This court has jurisdiction over the parties, the children, and the subject matter. So then it named the 3 kids. So then they say the respondent, who is EJ, has failed to comply with and or abide by the stipulated findings of fact, conclusions of law, order of judgment, and judgment of decree of divorce. Basically, he ain't followed what was in the divorce, okay? And the divorce was dated November 13th of 2017. So he's been divorced from this lady forever, and I think he's remarried, from my understanding. So that was entered into by the district court family division over there in Minnesota. The respondent agreed to the petitioner exercising said parenting time. So EJ is the respondent. He agreed that the ex-wife could exercise said parenting time prior to her traveling from Colorado and purchasing her ticket. So he told her, okay, you can get your parenting time. I'm about to get my tickets, right? Because I guess she in Colorado. So the respondent requested the minor child's passport under the false pretense on November 2024, and petitioner reluctantly sent the passport. That's when I stopped reading, because I was like, so I'm supposed to come pick the kids up, and you telling me that this man randomly said, hey, can I get the kids' passport? And nothing in your head said, well, I'm coming to get the kids, so what you need the passports for? Like, why would he ask for passport? Like, that's why it didn't seem plausible to me that he asked for these passports. I'm going to be perfectly honest. So what she did was say he asked for the passports, and she said, I reluctantly gave it to him. So she's saying she gave him these passports, all right? So then what she did was said, the petitioner, this is the ex-wife, is in fear that the respondent is making arrangements to flee the United States to Nigeria, which is respondent's country of origin. The respondent has threatened to take the children out of the country, and the respondent is in possession of the 3 children's passports. The respondent has refused to allow the petitioner to see the children and continue to conceal the minor children and their whereabouts. So maybe the children wasn't at the church or something, because I'm assuming they not at the church, because they was looking in trunks and stuff when people were leaving. But he's definitely easy to find, because that's why they was able to go to his church. He is a high profile person. And so I've served several celebrities with, well, I'm not going to say several, I'm going to say a few. I don't want to exaggerate. I've served some high profile people, or got them served lawsuits when they were in the midst of doing their shows, their stand-up comedies, whatever they were doing. There are certain places you can almost find, especially if they're celebrities, you can find them. Go look at their itinerary. Meet them in the parking lot. You know what I'm saying? Get you a private investigator, follow them to see where they're going. Because if he got the kids, he gonna see them sometime. So why not get a PI? So that part too was like, so he kept the kids, but it was easy for the sheriff to just go on Sunday morning and go see him in the pulpit. So anyway, the respondent has refused to allow the petitioner to see the children and continues to conceal the minor children and their whereabouts. The petitioner has made multiple attempts to have the respondent served with the pleadings. How are you having multiple attempts to have him served when he there on Sunday morning? We know where he at. He in the car. He on YouTube somewhere. He on Instagram. He one of them. Like he's one of the ones that, okay. But she can't find them, so she can't serve him no documents. So that's why she did this ex parte, which means it was one-sided, because she's saying she can't find him in order to serve him a regular motion, because allegedly he kept these kids. So that's why she was able to do this ex parte. Due to the respondent's behavior with regard to the minor children, it is reasonable to believe that advance notice of this motion and hearing date will cause respondent to flee and conceal the whereabouts of the minor children. The court has reviewed and orders the enforcement of the judgment, basically. So upon the evidence and the court's consideration, she did this as an ex parte motion, so it's one-sided. He didn't know nothing about it. Typically, when you file motions like safer, that's why I was shocked that they went this far, but I think them saying he was from another country and she allegedly gave the passports and all of that, the whole another country situation is that's even harder to get somebody back. So I could see that triggering the court to say, okay, this is an emergency. let me go ahead and get this, go ahead and get this. So they knew the trigger words to say, oh, I gave him the passports reluctantly, and he said he gonna take the kids to Africa. Unless she got some text messages or something, it just sounds a little set up-ish to me. But, that's just me. It's just my opinion from what I'm reading. So what the court did was they said, we're going to enforce it, when typically what you do is, if I got every other weekend as the parent, and then you got the weekends in between, but I keep them past my time, then I file a motion to enforce the custody or the custody arrangement or the divorce decree or whatever. And then you get a hearing, and that's kind of how that goes. Well, when you say somebody about to take some kids out of a whole nother country, of course, she was able to do an ex parte, which is one-sided. He didn't know nothing about it and did it on an emergency basis. That's pretty much how that went. So he ain't know nothing about it. So then the court ordered and directed any and all sheriffs of the state of Florida or any other authorized law enforcement officers in this state or in any other state to immediately take into custody all 3 minor children identified below from anyone who has possession and place the 3 minor children in the physical custody of the petitioner, who may not remove the minor child from the jurisdiction of this court pending further hearing. So this was actually filed in Miami. So now she has to get, the sheriffs were supposed to get these kids, put them in her custody, and she can't go nowhere, right? She can keep the kids, but she can't go anywhere. So then they're going to have, so if she in Colorado, wherever she was traveling, she ain't going there no more, okay? She got to stay right there in Florida with them kids. Upon the evidence, okay, so now they have it, neither party nor anyone at their direction except pursuant to the order may remove the children from the jurisdiction of this court pending further hearing. Should the non-moving party in any way violate the mandates of the order in the presence of the law enforcement, is to immediately arrest and incarcerate the offending party until such time as the offending party may be brought before the court and further proceedings. I don't think he was arrested because he was like all on live posts and stuff, but they're saying if he didn't abide by it, just arrest him. All sheriffs of the state of Florida and any law enforcement officers in any other state are authorized and ordered to serve and enforce this order in the daytime, in the nighttime, and any day of the week, including on Sunday, at house of worship, as he is a high-profile minister. So they put in there, this is where you probably find him at, which makes me wonder how she couldn't find him. Like, how you couldn't find him? Like, except as limited by the above, if necessary, the sheriff and officer and any other law enforcement officers in any other state are authorized to take all reasonable, necessary, and appropriate measures to effectuate this order. And then they got the 3 minor children, and they got their descriptions and all of that. And then it says the respondent has to provide a valid residential address to the court. The court reserves on the issue of makeup time, so she may be able to get makeup time because allegedly he kept the kids. The court reserves adjudication of contempt, including reserving any coercive penalties. And then it says, because the order to pick up the minor children has been issued without giving prior notice to the non-moving party, so the man didn't have no notice. It was ex parte. The respondent and the petitioner are ordered to appear before the court on January 13th of 2025. So they have to go to court on January 13th, 2025. Now, that's one hearing I wish I could be there to watch, but I have my own trial that I got to be at, okay? And that's in Miami, Florida, over there at the Lawson E. Thomas courthouse. So that's what had happened, okay? Yeah, it was ex parte, honey. It was one-sided. She told them that he had passports and he was headed to Africa. Right. Yeah, she's stuck in Miami. Experts is an emergency hearing. Yes, I've had one. Ex parte, I think it's what you meant. Sika said it definitely sounds like a line of setup. I'm just saying, it just sounds a little iffy to me. I don't know none of these people though. You know what I'm saying? So I don't know what they got going on. He of course he got on there and he says she's basically working with Lovey now or something. Let me go to his little Instagram. He has something to say about that too. Then on YNW Melly, you guys know that was another case that I followed. He said, hold on before I get to YNW. Yesterday was a defiling of the Lord's house, but I believe the Lord is restoring his fear to the church. It will happen. How can you defile a holy place? How can you defile a place? So basically, what he was doing was probably looking at the comments when people were like, y'all arresting people in the church. And so he made sure he made a post about that, you know. He said, I can't speak much on the children because of legalities, but God has given us victory. But know that it is proven fact that a certain, quote, camp has worked with my ex-wife to do this to me. So, of course, he blaming them other people. Searching church members' cars, that was crazy. They were literally, I guess when people was leaving out, they were opening up the trunks. I don't know. Maybe they were looking for the kids. I don't know what they were doing, but they were like looking in the members' cars. While you knew my children were on the way. So apparently it sounds like the kids weren't at the church. He must have called whoever had the kids and they were on their way to the church. And they still was looking at people's cars. So I guess they ain't believe the best. They ain't believe the prophet, okay? The Lord is fighting, but I thank God for the court system. This is a fight against the church. It's a fight against truth. Darkness won't win. You fight me, but can you fight everyone else speaking up? So he's saying, so he blaming Lovey and them, okay? I ain't got no time for the prophets that are fighting, okay? That's just too much. The prophets fighting, this has gotten way too out of hand. Henry said, it definitely seems like a setup. If she was afraid he would flee the country, why would you give him any passports that are in your possession? That's why they had to put reluctantly, because it didn't make sense. It wouldn't make sense to the average person that reads it. If we not getting along like that, then you ain't getting no passports. These passports ain't going nowhere till you show me some tickets that are dated for when it's your time. Like if you're going to take my kids to Paris in the summer, okay, for 2 weeks, you're going to need these passports, but then I'm going to need them back as soon as you land. If they allow that, because sometimes when you got these custody arrangements, they don't even allow you to go out the country, depending on how contentious your relationship is. Child, ain't nothing on that Stone Sonya that I know of. Last time I checked, she hadn't signed any responses or anything to that subpoena, even though I know that IS read something, but that's it. What else? What other questions you guys got, huh? Hit that like button. I stayed on extra talking about the prophets, and I really didn't want to. I read it. I was like, I just find it interesting. The pastor has all this anointing, yet stay in some bush. Listen. Some people are so heavenly bound, they're no earthly good, though. Because when you read some of this stuff, it's like, but my God is fighting for me. Pray, everybody. You listen, if you are not following the rules, I'm going to need you to follow the rules, okay? The Bible says to follow the law of the land. So what I need you to do is I need you to follow the law of the land. Everything is not the devil's. Now, I don't got all of the information. But I'm just saying, if you were supposed to, and you knew, if you know that she is working with this other, quote, camp, then why would you give any ammunition? Why would you? Why would you give her any ammunition? Them kids would be there early. They wouldn't be there on time. They would be there early. Do you hear me? And every time we talk to each other, it would be recorded. Or if I couldn't talk, like if we don't get along, they have systems in place for parents to talk through a system that's through the court. And you just say, I'm dropping them off at 7 o'clock. I'm a little late. I got to take them to the doctors. Can we do 7:30? And everything is documented. Now you know how this is. And maybe perhaps they have been co-parenting very well until now. I don't know. But if you know that you guys have this contention and you're remarried, some people don't like when you get remarried. You know, some women are different. For me, it was like, shoot, you remarry? Woo, I get to split these Christmas gifts. That's how I was with my kids. I was like, could you tell your girl that he wears a size 5? That's how I was. Like, When my son graduated, I was like, make sure she get a ticket because you know she covered a couple of birthdays. That's how I was. I ain't trying to beef with you. It ain't work out. It is what it is. But some people, they don't have it like they get upset about that, you know. So if you know it's going to be contentious, you put parameters in place in order for you to avoid that type of stuff. Nope, nothing with Jay and Busby yet, but I'm sure they'll help us. I'm sure they won't disappoint us this week. They are keeping the courts busy for all the wrong reasons. It's unfortunate. But that's it. All right, y'all. Ooh, my hair got even worse. I'm all sweating. I was all puffy. Jesus be a flat iron. Thank you guys again for supporting the platform. Make sure you hit the like button. Guys, any questions on Jake? We're going to watch. This is a developing story. Again, this is all alleged. This is what he's alleging. Jake said he ain't did not a doggone thing. And some of y'all believe Jakes and some of y'all believe Youngblood. So we'll see. What does the court believe? That's what we'll see. Who does the court believe? Who will the jury believe if it goes that far? Stay tuned. Thank you, Leandra. I appreciate that. You said, I mean, the devil knitting fireproof socks and getting added in. All right, y'all. I don't know. I feel like something else is going to happen as soon as I get off. That's how I feel. So Jake's attorney probably up there responding now immediately. They like, oh, hell no. This is what he said in this. Oh, no. This is unacceptable. Thank you, Miss Renee, for the Cash App, and I appreciate that. Like, oh, no. This is what's happening. I'm going to do a response right now. Let me double check these dockets before I get off of here. Good old Blackburn said he is entering the chat. My. So he is a part of it after all. So the new attorneys, they just did their notice of appearance. So when is he going to file his notice of appearance? He got to file one, right? I don't know. Thank you. I appreciate that. That is a great compliment. I appreciate that. Ingrid said, I believe in the report of the Lord. You so churched. Come on, Ingrid. Ingrid got that lap scarf. She got that holy oil. You got peppermints in your bag. You probably got a couple of safety pins. You still wear slips and stockings, don't you, Ingrid? I ain't mad at you, All right, y'all. Let me get off of here. Now I'm just clowning for absolutely no reason at all. Until next time, y'all know how I do. I'll holler at you later. Hit the like button before you leave, though. Okay? Bye.